Most of the time, a verbal agreement is binding in Texas. The problem is proving what you agreed to. Before you close another deal on a handshake, watch this video, because the law on verbal agreements in Texas may not be what you think it is. Imagine this. Texas business owner closes a deal with a vendor on a handshake. 6 months later, they're in a dispute and there's no document to look back at to see what the terms are. Unfortunately, a handshake isn't what it used to be. We're going to look at the types of deals in Texas that you can do with the handshake and those that we probably shouldn't. My name is Dustin Lee. I'm the founding attorney of the Sin Legal Solutions. We're a business law firm in Texas. Handle all types of business legal issues, everything that you can think of, from your entity formation to your contracts, commercial real estate to business disputes. Everything in this video is educational and informational only. Nothing in here is legal advice, tax advice, securities advice, financial advice, or any other type of advice. Nothing in this video creates an attorney-client relationship. In this video, you're going to get a straightforward breakdown about what a contract is, what verbal contracts could be enforceable in Texas or when they need to be in writing. You're going to look at the pitfalls of having a verbal contract versus a written contract, and we're going to look at when you might want to get an attorney involved. In Texas, a verbal agreement and a written agreement really aren't as different as you think. So we're going to talk about what the elements of a contract are and how one is formed. Texas follows pretty standard contract law, so the elements that you're going to be looking at to form a contract are, number one, an offer. One side makes an offer to the other side, and the offer is going to have some specific material terms in it. The second thing is acceptance. The other side has to affirmatively accept the terms of the contract, and they could potentially counter with a new offer, sort of a decline and a counter offer, or they may accept the original offer. A contract has to have consideration, and that's basically one of these fancy legal words for an exchange of value. So most of the time, you're going to be looking for one side to either get something of value or give something of value. You don't always have to get something of value. There could be an exchange, and the value that you're giving may actually be giving something up. But there has to be consideration, which is generally, kind of in layman's terms, an exchange of value. Next is a meeting of the minds. So there has to be sort of a meeting between the two parties or the multiple parties of a contract on what the essential contract terms are. This is what you think of as an agreement. There has to be an agreement or a meeting of the minds on the terms of the contract. No meeting of the minds, no contract. If one of these essential elements is missing, again, no contract. Now, on the meeting of the minds point, to go into that a little bit more, what do Texas courts really look at? They're going to look at what was objectively communicated and reasonably understood by the other side. Now, as you can imagine, this is one of the points where the verbal agreement fails in comparison to the written agreement, because with the written agreement, you have really express written terms about what the meeting of the minds is on to make sure that everybody actually does agree. With a verbal agreement, unless you've got a witness or recording or something like that, there's no way really to prove what the meeting of the minds was on. Then you end up in a he said, she said situation where you're having difficulty proving that there was a meeting of the minds and what it was about. Now, does your contract have to be in writing? Well, the statute of frauds does require certain types of contracts to be in writing, and we'll go over what those are. In general, unless it's covered by the statute of frauds, you probably don't have to have a contract in writing. A handshake, a verbal agreement probably is sufficient. However, the real problem that you run in there is not that the contract that's a verbal contract is unenforceable. The problem that you run into is how do you prove it? At the end of the day, the writing doesn't make the contract, it proves the contract. And the problem that most people run into is not the enforceability, it's the proof. If you can't prove it, then you can't enforce it. So, unless it falls under the statute of frauds, Texas can enforce verbal agreements. Now, there's things that you can do to make your verbal agreement more enforceable, some factors that we can look at. Obviously, the writing, even better. But let's look at, first of all, at what can we do to make your verbal contract more enforceable. Now, in my practice, I have seen courts uphold verbal agreements for all types of things, mainly around services or products that are being sold, transferred, but it could be in any other types of agreements that you can think of, as long as any of these agreements don't fall under the statute of frauds. So the fact that you don't have a signed written contract doesn't necessarily void the deal, but you may have trouble enforcing it because of a lack of proof. And that can kind of cut both ways. It could advantage you, could disadvantage you. What makes it more likely that a verbal agreement will hold up in court? Well, the first thing is partial performance. If one or both sides partially perform the agreement, it's more likely that that agreement is going to get upheld in court. So the next thing we're looking at is corroborating documentation or information. So things like emails, text messages, social media messages, or witnesses that observed the contract being made or observed the contract being performed. Things like that can go as circumstantial evidence to prove the existence and the terms of the contract. Another thing could be a course of dealing. If the parties have a course of dealing where they always deal with each other in a certain way through a series of transactions or this type of transaction, then that course of dealing could go to prove that there is a verbal contract that exists. Where are verbal agreements the most vulnerable? Well, the more complex they are, the more vulnerable they are, because it's more and more difficult to prove each and every one of those complex little terms and how those actually were agreed on verbally. Higher value contracts. Obviously, the higher value the contract, the more is at stake, and the more likely you're going to want to have a written contract rather than a verbal contract, because it's just going to be critical for you to be able to enforce the terms of the contract. What we're trying to avoid here is having a credibility problem where one side or the other comes into court and can't prove what they need to prove with respect to what the terms of the contract are, because at the end of the day, you can't ever determine how credible your witnesses are going to be in front of a judge or a jury. So if at all possible, you should try to get the written contract to avoid that. So unless it falls under the statute of frauds, what it really comes down to in Texas for a verbal agreement is, can you prove what the parties agreed to? Now, there are certain types of contracts that Texas law just expressly says these are not enforceable unless they are in writing, and that's the statute of frauds. Now, essentially, the statute of frauds is a legal doctrine or a statute that expressly states what types of legal agreements need to be in writing to be enforceable. The purpose of that is to prevent fraud in especially high-stakes transactions. Doesn't necessarily mean that an agreement didn't exist, but it means that you may have a difficulty enforcing it because you didn't get it in writing per the statute of frauds. So what are some types of agreements that must be in writing under the statute of frauds? Number one is a contract for the transfer of real estate. So like if you're going to buy or sell real estate. The second thing is a lease of real estate over a year long. The third thing is an agreement to promise to pay or guarantee for someone else. So for example, a personal guarantee like in a business transaction. Another one is something that cannot be possibly performed within 1 year. So let's say a 13-month contract where you have to pay every month. That would fall under the statute of frauds. Now, these aren't the only types of contracts that fall under the statute of frauds. These aren't the only types of contracts that need to be in writing. If you have a question about whether or not your type of contract needs to be in writing, you should consult a lawyer in your jurisdiction. Okay, so what happens if you have a contract that should have been written down according to the statute of frauds, but you didn't write it down? Well, the contract is not automatically void, but it's probably unenforceable. Now, there potentially is still a partial performance exception where if the parties partially perform the contract, you may be able to still go back and try to enforce that contract, but I would not rely on that. Really, what you need to do is initially going into your transaction, figure out if the statute of fraud applies, and if the statute of frauds does apply, then you need to get your contract in writing. So the key takeaway here is the statute of frauds doesn't care how clear it was, doesn't care if you had a meeting of the minds, doesn't care if you met all of the other essential terms of forming a contract. If it's not in writing, it's probably not enforceable. So get your contracts in writing if they're under the statute of frauds. Now let's talk about the real problem issue here is verbal agreements. Even though your verbal agreement may be enforceable under Texas law, proving it is a whole nother story. Now look, I grew up in the country where you had a handshake, your word is your bond, and people sort of live by that. But unfortunately, that's really not the case anymore, and I would never rely on a handshake just to enforce an agreement. At this point, it is absolutely critical for every business owner to get your contracts in writing. The real problem with that, when you get a verbal contract, a handshake agreement, you hope that you can rely on the other side, but if a dispute comes up, now you're in a he said, she said sort of situation, and there's no proof to be able to show a judge or a jury about what the actual terms of the contract were and where you had a meeting of the minds. Now, in combat sports like boxing or MMA, they have a saying that they use: never put your fight in the hands of the judge. Basically, it means, you want to try to knock the other person out or submit them so that you don't have to rely on the judge to award you the victory. The same thing here. Don't put your business, don't put your contracts in the hands of the judge or the jury. You want to rely on your own preparation, your own legal resources to be able to put into writing your contracts so that they don't end up in the hands of the judge or the jury later on. A major issue here is the more time that passes after a verbal agreement, the less likely you are, and everybody else is, to remember what the terms of that agreement were and what the conversations were surrounding that and entering into that agreement. The judge or the jury is then going to have to go back years later and decide, who do they think is more credible? Who do they think is telling the truth here? Which set of facts, which set of agreements, which set of terms do they think is the one that needs to be enforced? And newsflash, folks, it might not be yours. And if you do end up in court and something like this, opposing counsel is going to look at every statement you've made, every document, every email in your testimony. They're going to try to look at every single time that you have contradicted yourself. They're going to look at every single time that you couldn't remember what the terms of the deal were or how the deal was formed. These are all risk factors that can be avoided by having a written contract. Now, what can you do to bolster your written contract? If you do have one, well, go ahead and make sure that you save every email, every invoice, every text message, every social media message. All of these things go to bolster the fact that you did have an agreement. Document your partial performance and the other side's partial performance of the agreement in case anything does come up. So, while the law may say that your verbal agreement is valid, you may not be able to prove it up, and then it's not going to do you any good. Now let's talk about a few of the key terms that you probably would want to put in writing if you had a written contract. Now again, this is not an exhaustive list. You need a legal professional to draft your contract for you so that you don't miss anything. Because trust me, there's a million things that lawyers will think of because lawyers just sit around thinking of ways for the agreement to fail and then building that in and crafting that in and how to make the agreement succeed and how to properly document it. Most people don't have the experience or the knowledge in the legal profession to be able to do that or craft an agreement in that way. So because of that, you really ought to consult an attorney when you're drafting these agreements. But when you're drafting, you may want to come up with a term sheet or a letter of intent that goes over the major terms. And so the major terms that we're talking about for that are things like this. Who are the parties? Who's going to be the parties to this contract? What are they agreeing about? Is it going to be services? Is it going to be materials? Be very specific. Put in a very specific scope, very specific set of materials, very specific set of services, very specific set of goods. Be specific on your price. If you don't have a specific price, at least put in a way to calculate that specific price. Put in payment terms. Who gets paid? When? How? Time for performance. Who has to deliver what and when? How do they have to deliver it? What happens if something goes wrong? Is there a notice period? Is there a cure period? What constitutes a default under this contract? What constitutes a material term maybe versus a not so material term that's less important? The gaps are where most problems are created. And you can see just by that list, that's sort of the essential things that you maybe want to talk about when you have a contract. And obviously, if you've got a verbal contract to discuss, even just that limited list of things right there, that can become a very difficult contract to remember, to enforce later on down the road. That's why we recommend getting contracts in writing. And at a very minimum, maybe consider doing an email or a follow-up or some sort of confirmation in writing, even if the contract necessarily wasn't in writing. That sort of gap between the handshake and the confirmation take you 5 minutes and could go a long way later on to help both parties remember what their obligations are and to prove those things up in court if need be. Now, there is a point where doing this stuff yourself is going to go from saving you time and money to costing you time and money because these things end up in court. Now, obviously, as a lawyer, I'm going to tell you every contract needs to be in writing. Every contract should be drafted by a lawyer. In the real world, that may not make a lot of sense for things like small deals, quick transactions that aren't very high stakes. Obviously, we understand that there are situations where you may not consult a lawyer to draft a contract for you. But at the end of the day, as a lawyer, we say that because it's really important for you to protect yourself and to manage your risk. And so if you're able to get a lawyer on your contracts, you really should. If the contract value is significant, either just in relation to your business or significant just in general, then the likelihood is the amount of money that you're going to pay a lawyer to draft this properly is going to be far less than the amount of your money that you're going to pay to a lawyer if something goes wrong later. Complexity in a deal is a big signal that you need to get a lawyer involved. If the deal is, hey man, I'm going to loan you $20. You can pay me back next week. Okay, we get it. You don't need a lawyer for that. Now, if your essential terms of your contract are going to deal with a scope of work, transfer of a business, things like transfer of intellectual property, transfer of assets, transfer of real estate, and they're going to have lots of terms and delivery dates, this is something that you probably should consult a lawyer about. And just a word to the wise, the more complex a deal and the more high stakes a deal, the higher amount of money that's involved or the higher value of the stuff that's involved, the more likely it is that these DIY contracts and templates that you find online are just not going to work for you. You really need a customized contract to fit the ins and outs of your specific deal. And all of that stuff that you think is just legal boilerplate, there actually is a meaning behind every single one of those terms, and they're all important, and they can all be changed and tweaked to benefit you in your transaction. And for that reason, you really ought to consult a lawyer in deals like that. And just a practical tip that I see in my practice all the time: if you do have these handshake deals, these verbal contracts, it's always good to go back at least once a year and sort of reevaluate them, to take a look at, hey, are we performing? Are we not performing? Is the other side performing? Is the other side not performing? If this relationship unfortunately went sideways tomorrow, what could we prove? And what could they prove? That sort of proof gap between what you agreed to and what you can actually prove, that's your exposure to risk that you have right there. And so it may be worth it for you to have a lawyer look at these verbal deals or handshake deals that you've made and evaluate whether those need to be now memorialized in some sort of a written contract. So in this video, we discussed what is a contract, what's the statute of frauds, meaning what contracts have to be in writing. We talked about some of the pitfalls of having verbal contracts and some of the things that you may need to do to try to prove your verbal contracts up. The key takeaway from this video is not necessarily whether your verbal contract is enforceable, it's whether or not you can prove it in court. Thank you all for watching the video. If you want to learn more about me or Ascend Legal Solutions, business law firm in the state of Texas, go ahead and check out our website through the link below. Thanks.